Rico Silva in custody of Vashon. You know what that reminds me of, right?
Who was that?
Do you remember they had that song called Rico Suave? You can always tell people's age by their name.
Absolutely.
Like when that song Brandy came out, anybody whose name is Brandy, I know they were born in the 70s. Javier Salazar. And that's not the sheriff.
Sure.
And you, sir, what's your name?
Yes, Salazar.
Javier Salazar. See, I told you it wasn't the sheriff. Second row. All right, Mr. Beltran, if you can come down, please. How you doing? Good morning. So your attorney, he's not here, but he filed a motion to withdraw off your case. What I can tell you is usually attorneys will ask to withdraw from your case when they've concluded the trial portion of your case. And if there are any appellate issues, then usually an appellate attorney will be appointed to address that. Do you understand?
Kind of, I really didn't know why I was showing up.
Well, so you had a hearing on your case, and the hearing was on your case with regards to what credit you would receive?
Oh, yeah. For last
All right.
week.
Yes,
Okay.
and so your attorney has filed a motion to withdraw of your case because he says that he's done everything that he's contractually agreed to do.
Okay.
All right, so do you have any objections to his withdrawing?
No, ma'am.
Okay,
Yes.
yes.
And Tony said he's running late.
Well, we don't need him now. All right. You don't have any objections?
No, ma'am.
All right, thank you.
All right, you have a blessed day.
Oh, you too.
Yes, ma'am.
So we've concluded with Mr. Beltran.
Thank you, Judge.
All right, Matthew Salazar,
Yes, ma'am.
if you'll come forward, please.
Yes, ma'am. Yes, ma'am.
All right, so on this case, we had a motion to revoke. And so there was a tap to be done in custody completion. Upon completion of tap, he's to be released. What are the results of tap?
So the TAP recommends dual diagnosis outpatient program, monthly urinalysis, and documented sober support meetings, Judge. Upon speaking with Mr. Salazar this morning, he indicates that he has registered for the BIPP course. He had his initial evaluation completed. He did want to talk to you about that. And he also indicates that he was going to see about his attorney appearing today to try to get the no contact order adjusted.
All right. So you'll need to contact your attorney for that.
Yeah, that's right. He said he didn't know about this, so I don't know if he's coming, but okay, that's,
Oh, well, I mean, he can set a hearing anytime he wishes to set a hearing.
yes, ma'am.
But this is what I want you to remember. The last time I saw you, you were in Orange crying not to go to prison, right?
No.
So your minimum for this case is 10 years.
Oh.
I'm going to tell you what I tell a lot of people who come before me. If there's an issue, if you think you're going to use, if something's going up, you need to pick up the phone and call your probation office. Normally, all things considered, if somebody calls a probation officer and they have a drug issue and they say they think they're going to use, normally probation doesn't file a motion to revoke. They don't ask me to file a motion.
Yes, ma'am.
What they do is they'll send me notation saying defendant or the probationer is struggling with their sobriety. Then I will set it for compliance. I will call you in and I will ask you what we can do to help you maintain your sobriety.
Yes, ma'am.
So when people are placed on probation, I want people to successfully complete it. Probation wants them to successfully complete it.
Yes, ma'am.
So from here on out, everything you do, you need to be thinking, is this something that could potentially result in me going to prison for 10 years? So the no contact order is still in place. If you want that changed or have the opportunity for having it changed, you're going to have to show me something.
Yes, ma'am.
And what I can tell you is I require that your attorney files a motion for that. If you no longer have an attorney, we'll still put it on the docket.
Yes, ma'am.
And probation will reach out to whoever the subject is of the no contact order. And I like to have them come in so we can discuss things.
I'll just check, my father said she's here, and when I went out to call my attorney, she's down the hall.
Okay, well,
But I just thought you made me the chair, but. it's
no,
okay.
no. I mean, if everybody wants to have a hearing on it now, we can. Probation will let the family violence prosecutors know if this is a family violence case, that you're asking that the no contact order will be changed. I'll get input from them, input from probation, of course, input for you if you want to give it, and also input from the person who's the subject of the no contact.
Do you think it's better to do, like, to tell the lawyer and then do that, or,
No, okay, so here's the thing. I really cannot give you that type of advice.
okay,
But what I can tell you is if you don't have an attorney, it's going to get set anyway, because probation is going to send me something saying that this person wants to have contact with whoever the subject of the no contact order is.
Yes, ma'am.
And you know what I'm going to say? What does the state say? What does probation think? And then I'm going to want to talk to the subject of the no contact
Yes,
order
ma'am.
as well.
okay, I'll just wait and ask Ms. Mita this.
Okay.
Okay, and I was gonna ask you this, I asked the lady from the bid class if she could email you, like all my stuff, so you can see that, like, she look at what she says about me and everything. But she said it just goes to probation, but I wanted to know if I could give her your email, or you can send her something, so that way you can get all my updates and everything.
Oh, let me just tell you what ends up happening. Probation receives all that, and Officer Abrams receives all that,
Yes, ma'am.
and they always give it to me. So I'll know how people are doing
Okay,
in their classes.
And
And
I-
if there's an issue with the class, I always get an email about that.
okay, yes, I just wanted you to know everything, cause before, last time on probation, she just stopped responding to me, and I got severe PTSD, anxiety, and I got scared.
Well, here's the thing.
But now I know, everything happens, she don't answer me, I'm just gonna come into your courtroom and sit there and try to see
Yeah.
you, cause I know that you'll help me out. I
Yes,
know that my anxiety and my PTSD caused me to just freeze, but I'm just coming here because I know that that's what I have to do.
yes,
You'll help me, yes, ma'am,
yes.
thank you.
All right, so if you have any other questions about anything, let us know. And if there's something probation can help you with, let them know.
Yes, ma'am.
If you feel they're not addressing it, you can always come in here. If I'm here, we'll address it and figure out what's going on.
Okay, yes, ma'am. And then another thing, I just wanted to let you know that you gave me before 12, the NA,
Mhm.
and I've been doing it for over a year and I'm still going.
And how's that helping you?
It's good, very good.
Okay.
And then since I got out this last time, I started it all over again, but I've been going for a year already. It's gonna be yeah, exactly a year in February, so a year and 2 months.
And the reason why I do that is sometimes it helps you when you know that there are other people who are in the same position as
It
you
does.
are, and they're, trying to build their life back.
Yes, ma'am. And then when there's like, their experiences and their things and they're talking, it helps out a lot. And like, with my depression or being sad or something like that, it helps out a lot.
Well, I'm glad. And if you need anything, just let us know, okay?
Yes, ma'am. Thank you very much, Ms. Boyd.
All right, you're
Have a
welcome.
wonderful day.
You too.
Yes, ma'am.
All right, Mr. Outlaw, if you'll come forward, please. Hello.
I love it.
All right. So I actually, on the system, it had your court date is April 15th. So we can do one or two things. One, if you want to, you can see if you can get in touch with your attorney. And we can see if we can get in touch with your attorney to take care of things now. That way you won't have to come back on April 15th.
I have no idea what he looks like. I've called his phone, he's not picking up, so.
Oh, well, if you don't mind, I'll have the court call him. And I'll also text him and see if he can make it. That way you won't have to come back on April 15th. Otherwise, you're gonna have to come back on
Yes,
April
ma'am.
15th.
Thank you.
All right, let me see what I can do.
Okay, thank you.
You're welcome.
Mr. Outlaw?
Mark, one of your clients is here. He's not on the docket today. I think it's for the 15th. It's Eddie.
Oh, it was a pre-indictment setting. I'm not sure.
No, it's been indicted.
Oh, okay.
Yeah. So I'm asking him to bring the file down. I know you don't have any information, but Mr. Outlaw, this is your attorney here.
I'll talk.
Okay. Since he's set for April the 15th and you're here and he's here, I didn't want it to come back twice. Hello. All right. How are you doing today?
Be honest.
I'm just,
That's fine.
all right. Now, we have docket sheets, but now they require us to put everything in Odyssey. So why does he have a warrant?
The warrant, the MCR,
Oh, motion to revoke.
Yeah,
Okay.
it's motion to revoke. It was issued on March 28th. So it is less than a week old, Judge. So we got him into court as soon as we can. Thank
Okay,
you to
sure.
your wonderful coordinator. Getting this set so quick.
Awesome.
I think it makes a difference.
Oh, it does. I don't like for cases just to be out in the universe forever, because then when that happens, so much time elapses.
He knew he had a warrant. He knows why he's here. He's ready to address the court with that. And the quicker we get it done and the quicker he turns himself in, we figured that. I'm leaning on that one. And
Okay.
also my purple tie. That
Hey, I
one for
love the
LSU.
tie. Oh, LSU is out of the basketball tournament, but I always tell people they need to remember that the college players are teenagers. Don't lose your mind over a loss because they're already disappointed,
Yeah, they're kids.
All you can do is do your best. Andrew, are you ready on Ramsey Ibrahim? All right, the court is calling 2024 CR 3624 State versus Ramsey Ibrahim. Can I have the parties announce for the record?
Andrew Harris, Salem for the state.
And Andrew Freilich, Mr. Graham.
And are you Mr. Ibrahim?
Yes, ma'am, I am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Ma'am, I did.
Did you understand it?
Ma'am.
Are you the same Ramsey Ibrahim who was placed on deferred adjudication in 2024 CR 3624 for the offense of theft of service $2,500 to $30,000 on December 3rd, 2024 for a period of 3 years? Is that you?
Yes, ma'am, it is.
All right, state.
On or about the 10th day of February 2025 in Bear County, Texas, the defendant Ramsey Ibrahim did then and there fail to conduct himself in a proper and orderly manner when reporting to the supervision officer at the Bear County Community Supervision and Corrections Department in violation of Provision number 4.
How do you plead to that? True or not true?
It's unfortunately true.
I'm sorry, I can't hear it.
It's true.
True. All right.
State waives the remaining violation allegations, Judge.
No objections.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
No, Judge.
State, what are you requesting?
Adjudicate guilt, revoke supervision, assess punishment of 2 years of confinement in the state jail facility.
And defense, what are you requesting?
Judge, we're requesting my client be given another opportunity and allowed to continue his probation. My client would like to address the court.
All right. And you say your client would?
He would like to address the
All
court.
right, can you raise your right hand? Do you solemnly swear or affirm the testimony? All right, if you all could whisper in the box, please, just whisper. All right, do you solemnly swear and affirm that the testimony you give will be the truth and nothing but the truth, so help you God? All right, you're whispering.
Yes, ma'am.
All right. You can lower your hand, state your name for the record.
Ramsey Ibrahim.
All right, defense.
Ramsey?
So after the incident happened, I came to court and I was found, guilty of that.
You pled no contest.
Pled no
and you were
contest.
placed on probation.
Well, after that incident, I lost my job and then I've been seeing a therapist, a psychiatrist. Before all of this, I've had pretty severe depression and anxiety.
Judge, may I talk to my client for just a moment?
There's no justifying the attitude that I had through the things that I
All
said.
right, so what happened?
I lashed out by
How?
just not. I used a lot of. I was cursing, but not at the officer, at the situation. I was just.
Any
venting.
objections to the court review of the court summary?
If my client could be allowed to apologize before the court reviews the court summary?
No, I want to review the court summary because then I can have
I know.
more information about what's going on because he's not telling me everything.
I wrote an email one night. I wrote an email.
No. Any objections to the court reviewing the court summary?
No, Your Honor.
No,
I approach Judge. You
Yes.
don't already have a copy?
It's sent by email, and what I will tell attorneys, I receive emails from Officer Abrams, TAP evaluations, the PSIs, but I don't read them or open them until I ask both parties if they have any objections to my reviewing it, because I know it's hearsay. So since defense counsel doesn't have any objections, I am going to open the court summary and let me read it, and then I'll let you continue. All right.
There's no time to be allowed to continue.
Yes.
First and foremost, I apologize so much, so sincerely for the outrageous stuff that I said. I was in a really low spot, and
But according to the court summary, and let me explain something to everybody. I understand that people have, sometimes they're angry at their situation. Sometimes they don't want to accept responsibility for their situation. I understand that, right? So, but according to the court summary, they're saying that this isn't the first time that they've had an issue with you.
and that's basically the only notable time that we're.
Well, no, not only notable time. I'm just telling you what they say. This is what it says. It says, this is not an isolated incident. He has consistently exhibited defiance towards his probation officer and field officers, refusing to comply with basic probation requirements and making it clear that he has no intention of changing his behavior. So that's before the letter. That's what that seems to imply to me, that this isn't the first time. So they have the letter, and they're saying that when field visits are conducted, it's the same, similar things.
Okay, so like again, I'm very, very sorry. And this won't happen again, but as far as the field visits were concerned, I was thrown into agitation when the officer came.
No,
Hold on.
it's fine. I'm just trying to figure out what's
I
happening.
understand, Judge. What my client is saying is that before this motion to revoke was filed, before he came and talked to me, I don't think he really had a full understanding of what he was looking at and what the court may end up doing today. After I talked to him, and after I really informed him of what he was looking at, and what the court might do, and after hearing Mr. Edelman say what they're requesting,
Mhm.
I think you can see my client's attitude has shifted.
Mhm.
I want what Ramsey was talking about, Judge, is he had a bad attitude. He just played true to a condition that I've kind of never seen on an NCR before, of just not fail to report, not the rest of it, but fail to conduct himself in a properly and orderly manner. He's pled true to that. He's accepted responsibility for that, and he has promised that he's going to make a change. I think that since I have had the opportunity to talk to him about realistically what he's looking at, should he not, in the rest of his 3 years of probation and the conviction and the 2 years day for day,
Mhm.
that his attitude has shifted in a remarkable way. He's willing to apologize to each one of those officers if he's offended, apologize to the court, apologize to the prosecutor if need be. I just want to make sure that the court understands and sees his change in attitude. That's why we're here, is his attitude is poor. Was poor.
I sincerely mean my apology.
All right, so my question is, I'm back to my question. So it's stated in the court summary, this is not an isolated incident. So when they say it's not an isolated incident, I'm taking that to mean the email that you sent, right? So let's not even talk about the email. So they're saying you have consistently exhibited defiance towards his probation officer and field officers. And the field officers are the people that go out to see you, because I require that their field visits. And actually your probation, I don't do cookie cutter probations. Your attorney will tell you that.
That's true.
Your probation that I gave to you in the big scheme of things, the conditions that I've given people, it wasn't that much. You didn't even have restitution to pay because I guess people received their items, but you were only 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, field visits one time for 3 months, and 200 hours of community service restitution in the theft course. That's all.
Just a second.
Yes.
Sorry, Judge. What my client is concerned about is that yesterday
Mhm.
he made a payment to pay off his community service hours.
Okay. Oh, no, that's fine.
Again, that's what he's trying to say. And you're looking for a job.
And the restitution, I think.
You paid the restitution in full before the plea judge.
Yes.
That was part of,
Okay.
as a plea bargain, he did pay the restitution
All
up
right.
front. That's why it's not a probation condition. So, and again, in this past week, I want to make sure I got it. He has registered for the theft class. He has paid his community service hours off in full. He has reported here today. He has apologized for his behavior. I think that in the past week since this MTR was issued, he's gotten the message.
All right. And how old are you?
40.
40. Okay. All right. Is there anything else?
I want to give you one opportunity, just sure what we talked about. So, go ahead and address the court.
Yes, I'd like just to reiterate, once more that, I mean, I am immensely sorry for having offended everyone there. Had, spoken ill of.
Mhm.
And the attitude, I mean, you're gonna see a complete difference of everything going forward. If you just please give consideration to allowing me to just get back on track, and I'll make good on on the conditions. I absolutely will. I was just frustrated with the situation, and I lashed out.
All right. So let me explain something to you. So now let's get to the letter that you wrote. It takes a lot to send an email to somebody. And what you said is I'm literally cast aside and blacklisted on the same level as effing rapists, pedophiles, and effing real felons. You're in felony court. Sometimes people think that, oh, I'm not like other people who are charged with crime. And then you say, I hope a prison convict breaks out, rampage rapes all the aforementioned, and give them AIDS. It takes a lot of anger to write that and to send it.
So after I got this recent denial from the perspective of
And that was sent on March 26, 2025.
there's no justifying that level of right. I mean, I'm embarrassed to having to hear it. And it was at my lowest point, and there's no yes, I was angry.
Oh, State, you may continue, you're excused, you may continue to confer.
Thank you.
Yes, but I mean, I'm telling you, that was at a point of just ultimate low. And
Excuses.
there's not an excuse. There's just a sincere regret.
Judge, my client would like the opportunity, if he's allowed to continue his probation, to apologize individually to each one of those people. If you would like to make that a condition, that would be great. I know it's usually outside of what we do, but it wouldn't be unusual for you to allow him to apologize.
Mhm.
And I do apologize to you.
All right, I understand. And I understand that people are angry sometime. All right.
Judge, we would ask also, as an additional condition, if we could add a cognitive behavior course or an MRT course to those that may assist him.
I just started seeing a therapist and talking to a psychiatrist.
I think that I think the court can see that he clearly has reading and hearing what he wrote. I think that the court can see his sincere level of apology and wanting another chance.
All right. And probation, what are you recommending?
The court summary indicates revocation. Mr. Abraham has only been on probation since December, and although
He did sign his letter, yours truly. I think there should have been another thing other than yours truly, maybe with regards or something.
Agreed, Judge. The court summary says revocation. I would say that he could benefit from some courses like the cognitive behavior course and more recognition therapy. There has been, I know the court reviewed the court summary, and you can see that there was some positive urinalysis that were waived by the state. However, he did produce a copy of his prescriptions. No prescription for alcohol, so that is something that we would have to really hone in on. But as far as the other positives for actual substances, I do have prescriptions for those. And he did provide the receipt for his community service hours. The community service hours were paid to Feeding America, so I would ask the court for taking that into consideration. Other than that, Judge, that's all I have.
So are you asking for revocation? I understand the officers requesting revocation, correct?
That is correct.
All right, thank you.
And if I could, Judge, I understand why the officer would recommend that after reading those emails. Again, I would ask for the courses. I would ask that the court allow my client to issue a full apology, email, handwritten, or in person, however the court wants to do that. If my client is allowed to apologize,
I'll do all of the above.
he is taking this quite seriously now after our conversation. Whatever the court would like to do, we'd ask that he be continued.
All right, this is what the court is going to do. The court is finding violation of condition number 4 true. The court is going to find you guilty. The court is going to revoke, sentence you to 2 years in the state jail facility, give you credit for any time served, and the court will retain jurisdiction.
Thank you, Your Honor.
And you can explain to your client what that means. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
All right. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Because this is not a plea bargain agreement, we do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision or deferred adjudication. Do you understand? And you can explain that to him, counsel.
Thank you for that.
You're welcome. All right, who is here on Shauna Taylor? It says Shauna Taylor.
Yes, Judge, same person.
All right, thank you. Hello. All right, the court is calling 2024 CR 6075 State versus Nita Michelle Taylor. Could I have parties announced for the record? State,
Andrew Harris, Adelman.
defense,
Thomas Beck for defense.
and are you Nita Taylor?
Yes, I am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, I did.
Are you the same Nita Michelle Taylor who was placed on community supervision for the offense of theft of property less than $1,500, 2 or more previous convictions on January 7, 2025 for a term of 5 years? Is that
Yes,
you?
correct.
State?
On or about the 8th day of March 5 in Bear County, Texas, the defendant Nita Michelle Taylor committed the offense of theft in violation of condition number 1.
How do you plead to that? True or not true? True?
True.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion? Just one moment. All right, if you all could step back, the judgment on this case is incorrect, so that there needs to be an amendment to the judgment because this is a 3rd-degree felony. It shouldn't take that long.
What needs to be done?
Oh, the judgment needs to be amended because the judgment has this listed as a state jail felony, but it actually is a third degree. So it won't take that long to do it. Yeah. This should be listed as a third degree felony and it's listed on here as a state jail felony.
Could I approach Judge?
Just give me a moment. I understand you're ready. Just give me a second. They've amended everything. So,
I don't think anything's been done.
yes.
Oh, okay, but she was just asking, because she was here for the public.
All right.
I just have a small thing to say, Judge.
All right, just give me a moment. I need to put this in the system. Yes. Yes.
Judge, I'm not sure what's going on.
Oh, the judgment was incorrect. So it's a third degree felony. It's not a state jail felony. It was listed incorrectly on the judgment. So they've corrected the judgment and we cannot proceed unless the judgment is correct.
Okay, can I be excused if we're not gonna have the hearing or?
We are going to have a hearing. What I'm telling you is they had to
No, I got
correct the
you.
judgment.
So they
Yes.
corrected it.
Yes.
Okay, good.
Okay, no problem.
Because Judge, I have other courts to go to. I know you're extremely busy.
Yeah, I mean, I understand everybody's busy. I mean, it takes a while for them to correct the judgment. They're telling me that they've corrected the judgment. I just finished this case, so I will
Thank you.
call your case.
Everything's perfect.
Thank you.
Appreciate it, Judge.
Uh-huh. All right, court is calling 2024 CR 6075 State versus Nita Taylor. Could I have parties reannounce?
Andrew Harrison, State.
Thomas Beck for defendants.
Hi, and are you Miss Taylor? All right, so Miss Taylor, the judgment was incorrect in your case. The judgment showed that this was a state jail felony. All of your plea paperwork shows that this is not a state jail felony. So I wanted to make sure that that judgment was corrected. All right. So the judgment has been changed to reflect that this is a third degree felony. Do you understand?
Yes.
All right. So you entered a plea of true to a violation of condition number 1. Do you understand that by pleading true to violation of condition number 1,
Yes.
the court could revoke your community supervision and sentence you up to 6 years in the prison? Did you understand?
Yes.
All right, knowing that, do you still wish to plead true to violation of condition number 1? All right, the court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Judge, revoke supervision, reform the judgment, and sentence to 4 years of confinement.
TIC.
And TIC, the 2 new number 1s.
And these are the 2 cases that are within the motion to revoke?
Yes, Judge, 2025 PF 08971 and 2025 PF 08972.
I'm sorry, 2025 PF 08.
971 and 972.
All right, are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal? All right, the court is going to grant the motion. The court is going to revoke, sentence you to 4 years in the prison, taking consideration 2025 PF 08971 and 2025 PF 08972. Give you credit for any time served. All right, good luck to you.
Thank you.
You're welcome.
Oh, thank you, Judge.
Sure,
I've got a little impatient, so.
no problem. You may be excused. All right, thank you.